Okay, I believe we'll get started. I'd like to welcome everyone to this virtual question and answer event on the UNIDROIT Model Law and Factoring. And I'm happy to see a lot of very familiar faces in front of me on the screen, and quite a few new faces as well. So it's wonderful to have so many people joining on today. It's my pleasure to chair this meeting in my capacity as chair of the expert working group charged with actually drafting the UNIDROIT model law on factoring. Now, today, in this short period of time we have, there's really three objectives we'd like to cover. First, we want to introduce the model law on factoring to stakeholders, to people that may be interested in the project and have only recently learned of the project and haven't had an opportunity to really study what it is. The second objective is to give stakeholders, those that are interested, a chance to ask questions about the model law. And finally, and probably most important, a chance to ask questions about the current draft of the model law. The consultation window that is now open for input closes in about a week. And so we're hoping that those that have questions or concerns or observations will give them to us fairly fast. Two parts to this afternoon's event. The first part, we're going to have a short briefing by three people. First, William Brady Watson from UNIDROIT will introduce the model law and explain what it is. Second, Murat Sultanov from the International Finance Corporation will explain why there is a need for this particular new instrument. And then third, Marek Duvovec of the International Law Institute will survey the content of the draft model law and highlight some of its key features. In the second half of this session, we're going to invite comments and observations from people who are participating today. And as we begin that second part, we're going to have some short presentations on two of the industry players that have been very, very active in helping us formulate this model law, and that's Richard Cohn and Peter Mulroy. Now, if you have comments or questions, you can use the raise hand function, which we're probably all very familiar with by now with Zoom. Or you can just put your questions in the chat box. And either way, we'll be able to address them. And so with that little brief introduction, let me, Will, would you like to get us going and kind of give us an overview of what we're doing here?
Thank you so much, Henry. Can you see my screen?
Yes.
Wonderful. Good morning, good afternoon, good evening, everyone. It's a pleasure to welcome you to this event and to provide a couple of minutes introduction. Now, given that we have almost 40 people online and 60 stakeholders registered, very much the focus of today's event is getting input, feedback, and answering your questions. So I'm going to be extremely brief in introducing UNIDROIT and the project, but I thought it was worthwhile to do so just in case there were some new stakeholders who have just only engaged with the project who may not be so familiar with our institute and our work. So the model law on factoring is being developed by the International Institute for the Unification of Private Law, or UNIDROIT. As you all know, UNIDROIT is an independent intergovernmental organization that was established in 1926. It has 63 member states from around the world, all of the continents, and UNIDROIT membership covers 73% of the world population and 90% of global nominal GDP. Now, UNIDROIT's statutory purpose in our statute is to modernize, harmonize, and coordinate private and commercial law. And we achieve this objective by developing treaties, model laws, principles, and legal guides. We are very much a legislative body, and we have a very successful history in that regard, having produced over 30 instruments throughout our time. Now, as a result of our global membership and our successful legacy in producing legislative instruments, In 2019, the World Bank Group submitted a proposal to the UNIDROIT Governing Council for UNIDROIT to prepare a model law on factoring as part of its 3-year work program. And that was really the genesis of this project. So the model law on factoring was accepted on the UNIDROIT work program in 2019 as a high priority project. In 2020, once it had been accepted, UNIDROIT created a working group of international experts from different legal systems, representatives of relevant international organizations, and private sector associations to really develop and negotiate the instrument. So this is not something that UNIDROIT is doing in-house. It is very much being negotiated by a group of independent international experts with input from international organizations and the private sector. Now, we are very much advanced in the development of this instrument. The working group has been working hard over the last 2.5 years, over 5 sessions, to prepare a draft of the model law on factoring, which we now have before us, a complete draft, which was approved by the Governing Council early this year. The Governing Council authorised the Secretariat to initiate a public consultation on the draft, which is where we are right now, as Henry foreshadowed at the start of this webinar. So following the conclusion of the public consultation next week, there will be one further working group meeting at the end of this year to finalise the draft. It will then be adopted by the Governing Council next year and published by the end of the year. I also note that once the model law on factoring has been published, UNIDROIT has also been authorised to develop a guide to enactment to assist implementing states, but that will be a separate product that will be developed once the model law on factoring itself has been concluded. So today's event, we want to emphasize, is very much part of this public consultation. It's not a standalone event. The public consultation under this initiative, we've launched a dedicated website. We have circulated the draft model law on factoring with some introductory remarks as part of the consultation paper, and we have promoted the model law on factoring at a series of events, this one being the most important one. Now, the purpose of this consultation, and thereby somewhat the purpose of today's event, is to raise awareness about the instrument, ensure it's well suited to application in different contexts, including both civil and common law jurisdictions, as well as developing economies, emerging markets, and developed economies, to seek feedback from parties engaged in factoring, the 40 stakeholders we have in the room today, predominantly, to make sure it sufficiently addresses the issues that you experience in undertaking factoring arrangements in your jurisdictions, and of course to solicit comments on the drafting of the instrument itself. So to wrap up, we really emphasize that that we would like people to engage now, stakeholders to engage now with the model law on factoring project. Now is the time to give input to make sure that it will assist you in carrying out your factoring business, especially in cross-border circumstances. So comments are due next Friday. They can be submitted to that email address there. And today's session is really about and provides an initial opportunity for stakeholders to make comments, to ask questions, and to seek guidance in preparing their submissions on the draft model law on factoring to ensure that they can be considered as we wrap up the instrument. I'll leave it there. Thank you very much.
Thank you, Will, for that excellent background and overview of the project. I'd like to now give the floor over to Murat Sultanov from the International Finance Corporation of the World Bank Group. Murat is a senior operations officer and has had significant experience in the design and implementation of factoring model laws around the world. And Murat will explain why this particular instrument, our model law on factoring, and the gap that exists in the law makes this an important and useful instrument. Murat?
Thank you very much, Henry. Good morning, good afternoon, and good evening, everybody. As Henry introduced me, my name is Murat Sultanov. I'm based in Istanbul. I'm with IFC's Financial Institutions Group. IFC is the private sector arm of the World Bank Group. We are a private sector investor and a provider of advisory services to a broad range of public and private sector stakeholders. I'm covering primarily regions of the Middle East, Europe, and to some extent South Asia. but previously I've been working as a global specialist covering a wider geographies to facilitate the implementation of secure transactions and collateral registry reforms. I'm currently connecting from the Republic of Georgia, where I'm on a mission to kickstart the new IFC project on asset-based finance. This is a newly approved project that will work for about 4 years with a wide group of stakeholders, financial institutions, non-bank financial institutions, government agencies on creating a ecosystem for asset-based finance that includes different products on the supply chain finance spectrum, pretty much all types of financing products where movable properties are used as a security, whether tangible or non-tangible. And definitely receivables-based products is a centerpiece of this program. We have learned today during the mission that there are currently initiatives taking place in this republic to draft and enact factoring law that is supported by our colleagues from the European Bank for Reconstruction and Development. This is going to be a very important piece of legislation to really kickstart factoring programs. And that has been actually illustrated by one of our meetings with the leading bank here in Georgia, who last year have decided that they want to pilot both factoring and reverse factoring programs. They have invested considerable amount of money in setting up the electronic platform. They have set up and created a unit, hired teams, invested in designing legal agreements, and they started quite well, but then they had to put the program on hold. And among the reasons, the bank mentioned that we are not comfortable proceeding and scaling up this product because there's still no news on the enactment of the factoring law. And the reason why they consider this to be so important is because there seems to be confusion on a number of things when it comes to private law aspects, but also regulatory aspects. On the regulatory side, they're not really sure how this product will be supervised from the provisioning standpoint and prudential regulation standpoint. But on the commercial, on the private law side, they are very confused about registration issues. The factoring law is calling for the creation of the registry, where these companies will be able to register the rights in these receivables to protect themselves against the potentially intervening rights of other parties. And this infrastructure hasn't yet been created. And there's a bit of a confusion we've learned this week between what this factoring registry in fact should be, whether it should be a contracts registry or invoice registry or registry of notices of rights in receivables. We've explained that it really needs to be the latter because incidentally, the World Bank, International Bank for Reconstruction and Development, is actually working also with the government on reform of secure transactions and establishment and creation of the collateral registry. And it seems like the same unit within the same government agency what actually didn't really add a 2+2 to realize that essentially it's the same program or it's the same platform or same registry that really needs to be operationalized. So we help clarify that. And I think the UNIDROIT Model Law, which really creates a very clear and understandable link with the publicity scheme designed under Model Law on Secure Transactions of UNCITRAL, really is going to help clarify some of this confusion that is now taking place in places like Georgia and in other markets in terms of what type of registry should be in fact operationalized under the factoring law. That, of course, is let on all other important aspects on the contractual side between different parties that can significantly help structure the agreements and protect the rights of all parties, factors, and others as they execute these transactions. So this program in Georgia is Georgia is one country of the program, but the program also works currently in Ukraine, in Azerbaijan, in Uzbekistan, and Tajikistan. We have recently launched a similar program. And in all of this jurisdiction, there are some initiatives to introduce a standalone law and factoring that really should be kind of complementary and work hand in hand with the broader secure transactions legal framework in these markets. And IFC is really helping sort of connect all these dots to make sure that the legal framework is fully in line with international standards. It can be benefited by different stakeholders once in place. And so that banks like the one that I mentioned here in Georgia do not put the programs on hold because of this regulatory regulatory and legal uncertainties. So the UNIDROIT model law, we expect, certainly will help address these uncertainties that are taking place when governments embarking on the different projects to reform the private law framework for factoring and receivables finance. So I'll stop here. Henry, back to you.
All right, thank you very much for that important aspect of our project, and that's why it is needed. And I think it's particularly important that you pointed out that countries that are trying to create finance law are running into some uncertainties and some difficulties, and the model law is designed to make those uncertainties and difficulties sort of go away, that we're trying to lay a framework both for the legal background as well as the registries that will be necessary. So again, thank you very much for that. Our next speaker is Mark Dubovec from the International Law Institute. And Mark has been, from the beginning of this project, very, very involved and has for years, for those of you that know Mark, you know that he's been involved in secured finance laws around the world in various aspects. So he's going to give us an overview of the model law itself and get into that to give us a sense of how the model law works. Mark, please.
Thank you, Henry. Good afternoon or good morning to everyone. I have prepared a few slides to walk us through some of the key features of the model law. But first, thanks to Murat for reminding me of the good times we had in 2019 in Georgia, working together on the secure transactions law and coming across another project on factoring, which incidentally, one of the initial discussions we had with a local group of stakeholders was that their initial draft was based on the civil code provisions governing the transfer of claims. In other words, transfers of obligations rather than transfers of rights. So there was a fundamental problem as a starting point to the project itself, but I'm glad to hear that it's been evolving and that Murat is involved. So I will provide some overview of the structure of the draft factoring model law. We don't expect the structure to change at all or much during the last meeting of the working group, although there will be a need to finish some provisions and articles in the draft itself. So the draft contains 9 chapters. I will on my next 2 slides just highlight some of the key aspects of the relevant chapters, but the first chapter governs scope and general provisions. So in addition to the usual scope provision and definitions, we also have some rules of general application, such as the parties must proceed in good faith and in a commercially reasonable manner. Chapter 2 governs transfers of receivables, which is the equivalent of creating a right in a receivable or some kind of other property right, which requires a simple agreement between the 2 parties, the transferor and transferee, which makes the transfer effective as between the 2 parties to the agreement. The next chapter covers transfers of receivables and the mechanisms that make those transfers effective against third parties. And after some discussion, the working group decided, in accordance with the recent international standards, that registration will be the sole method to make transfers effective against third parties rather than notifications or simple execution of an agreement, as is still the case in many jurisdictions. Then we have rules on the registration system, which are amplified in an annex to the model law, particularly for those states that have not established any form of a public registration system yet. So they will be the ones needing this kind of advice in terms of specific operational and administrative rules to run a registry for factoring transactions. However, for many states, such as Georgia that Murat mentioned, but also UAE, Jordan, and a few other projects that I'm personally involved in, those jurisdictions have already enacted secure transactions laws and already operate a registry, so they might not need that kind of advice, hence the decision to put the bulk of registry provisions in an annex. The next chapter covers priority, which is very simple. Since registration is the sole method to make transfers effective against third parties, the date and time of registration then determines who has priority among competing claimants. Then we have a set of contractual rules that detail rights and obligations of the parties, which could either be the parties to the transfer agreement, the assignor and assignee, or transferor and transferee, but also debtors, who are the persons that owe the payment of receivables. The next chapter covers collection and enforcement, which essentially provides for extrajudicial enforcement mechanisms, either in the form of collection, but also in the form of sale of receivables in case the transferee decides to sell a package of receivables rather than collect them one by one. Since factoring is increasingly conducted on a cross-border basis, we consider it very important to include a set of rules that determine the applicable law, particularly to the perfection, third-party effectiveness, and priority, which is the location of the transferor. And then finally, we have a set of transitional rules that provide how an existing transfers of receivables would be protected after the new factoring law enters into force, and what sort of actions the transferee might need to take to ensure the continued protection of its rights established prior to the new factoring model law entering into force. So with that background, some of the key features. The first and probably the most important feature is the broad understanding of factoring, which relates to the narrow understanding of factoring in the 1988 UNIDROIT Factoring Convention, which was essentially limited to absolute assignments of receivables that required notification. We have, in fact, conducted some background studies, and we polled the industry. Hopefully, Richard and Peter could also speak to that in the next session, as to the types of transfers that factoring companies today take, and they uniformly stated that not only absolute assignments, but also security assignments have become quite common. So the factoring model does apply to security and outright transfers, whether or not a notification has been sent to the account debtor or debtor. It also applies to specific types of receivables, as this is a factoring law. It's not a law on general assignments of receivables. And we know there are specific statutes that may govern certain types of receivables. So we focus primarily on the trade receivables, which are rights to payment arising from the sale of goods or provision of services. But the definition of a receivable is slightly broader than that, also applying to receivables arising from a disposition of intellectual property rights, such as a license of IP, as well as data receivables that may arise from some disposition of data in a transaction, as well as credit card receivables. As again, we heard from the industry that these are the types of receivables that are commonly factored these days. The fourth important feature is the complete override of contractual limitations on the transfer of receivables. This has already been done to some extent in the international standards published by UNCITRAL, whereby any limitation that may be included in a contract that gives rise to a receivable is ineffective, so as to allow the transferor to transfer the receivable to a transferee and obtain access to credit. So the factoring model law took another step in this direction and actually rendered these clauses wholly ineffective, so that the debtor would not even have a right to claim damages for the breach of that clause. The final set of features which I would like to mention concerns the registration and priority. As I mentioned, the time of registration determines priority, and we had some discussion in the working group as to some of the alternative methods, but uniformly, in light of of the recent developments and the international standards, there was almost a unanimous agreement that registration and a notice-based electronic registration should be the method that is recognized by the factoring model law. And as I explained, we included some registry-related provisions in an annex that hopefully many states will find useful. I already explained that the factoring model also contains some rules on the applicable law, which again, in the past 2 decades, generated some discussion as to what the connecting factor ought to be. And in accordance with the already existing international standards, we settled on the location of the transferor, which facilitates the perfection and determination of priority for various transfers and competing transfers. And the final aspect, which Will alluded to in his explanation on the path that this project has taken and where it is leading, there will be a guide to enactment, which will, for instance, cover some of the aspects that Murat mentioned, particularly regulatory aspects, which are increasingly important in the implementation of reforms, particularly the licensing of factors, especially those that are non-bank financial institutions, as well as some prudential aspects and accounting aspects. But these are obviously matters that are more appropriate for the guide to enactment, as regulation is not part of projects and products that are developed at UNIDROIT, but we're happy to see that some of these aspects will provide guidance in the implementation. So with that, Henry, over to you. I will close my remarks. Thank you.
Thank you, Mark. It was excellent overview of our project, and I think really gives a sense of where we are and what this project is intending to do and how it will achieve that. We're now going to move into our comment section and questions that people may have. But before we open the floor to general comments, I want to give two industry representatives who've been tremendously important in this project an opportunity to make a few comments. That's Peter Mulroy and Richard Cohn. Peter is the Secretary General of FCI. He's been in that position since 2012. And Peter has been extremely active and important in the project to make sure that the model law fully reflects the needs and structure that the industry needs, as has Richard Cohn, who's a partner at Goldberg Cohn, the Chicago law firm, and chairs the Secured Finance Network. He's involved with that. So we've got two very important industry representatives here, let me start with Peter, and then we'll go to Richard, and just give you a few minutes to make some comments to everyone about where the project is and how you think that it's worked along in terms of industry. Peter?
Thank you. Great to be here, and I'm delighted that we're at this juncture. It's been a long process. I think the initial seeds were planted back maybe 2017, 2018. The first thing I'll say is that I from the very beginning, I've been very impressed with the fact that this initiative has been, in a way led by the industry, in a sense that it was really a kind of a down-up initiative, which is really kind of unusual in a sense, because many of these typically are very much top-down and pushed down, and I think this one was really well harmonized. When talking to Murat in the early days, when IFC was really encouraging the creation of this factoring model law, they were hearing very clearly in the market, as we were, that there was a real need, a need across the board in terms of course, just the general comprehension of this concept, but also the need basically to have a really sound legal framework, and especially in these newer emerging countries that really historically have just never utilize receivables as an asset class to liquidate and finance their working capital for SMEs and corporates. So that's one of the things, first things I'll say. Second, this model law aids, SMEs and corporates. I mean, at the end of the day, this is why we're doing it. They don't have many emerging countries don't have access today to this ability to finance against their receivables. And I remember reading a study that globally, on average, as a percentage of the total assets of a company, 40% of those assets are receivables, and typically in emerging countries typically lie dormant, and they just sit there until they're liquidated. So this is another like a major reason. The third observation, of course, is the fact that this industry is a hot potato. I mean, it's been growing exponentially, approximately 8.5% compounded from a little over $500 billion 20 years ago to over $3.5 trillion today. It's just astronomical growth. I know that EUF, European Union Federation, just reported in the EU countries the growth of 20% in 2022 year to date. Excuse me, through the first 6 months. FCI has reported cross-border activity up 15% last year, 33% this year. So I mean, it's just a phenomenal right now, and especially this is seen typically after every major crisis. But the truth is, all these countries these emerging countries that don't have legal framework, that don't have the capability of an investor or entrepreneur being able to provide this service, they don't have this capability, so they're not able to generate and enjoy this huge surge in growth in our industry. And that's a shame. And on the flip side, that's the huge benefit of this project, we know that when any country adopts the sound legal framework, we've seen this in numerous countries. And I remember 3-4 years ago, we did a study just to see the percentage of growth after an adoption of a legal framework. And the adoption has been always double digit. And, we can see that in Egypt. We can see that in India. I mean, I can go on in the success of the adoption of the legal framework. Lastly, I'll just say that, this is a harmonized law, meaning we're able to kind of now have one ring to rule them all, as they say in the Lord of the Rings. Just one model law, that we can point to and we can support, and hopefully we can get everybody on board. And I'll just close by saying we have at FCI we've delivered this to over 400 members around the world. I know. The EUF has also delivered this through the national associations. We also included other associations, banking associations, and factoring associations around the world as well. So this has been well distributed, and we're getting a lot of feedback. And I know this next week you'll get a lot of information from FCI. So I thank you, and I'll stop there.
Peter, thank you very much. And as usual, I was scribbling down a lot of the facts and figures that you were giving, because as soon as this session's over, I've got to walk across the street and teach my class receivables financing. That's what we're doing today. And I'm going to throw some of these numbers at them just to emphasize the importance of factoring and as a means of financing. One point that I'd like to emphasize that you made, and that is that there are various attempts out there to come up with a model laws of factoring, and we've attempted, by getting the industry input and expertise, to come up with one that is as good a product as can be, so that we can go out and introduce it to places and say this is something that you should consider, that we've tried to have it as defect free as possible. Again, thank you, Peter. Richard, please.
Hello, everyone. As Henry mentioned, I'm here on behalf of the Secured Finance Network, and we are the principal U.S. trade association for asset-based lenders. And our members include most of the major U.S. money center banks as well as many small entrepreneurial finance companies. And we've had the honor of being an observer on this project, and we've also been very active in secured transactions reform projects for UNCITRAL and other organizations over the past 20 years. So let me just begin by saying that I'm going to echo a lot of what Peter said. I'm a big fan of this product. I think it's excellent. When I look at a proposed law such as this, I try to evaluate it using two different tests. First, does it work purely as a matter of secure transactions reform? Will it promote the availability of low-cost secured credit for small and medium-sized enterprises in states that adopt the law? Not only in developing economies, but in developed economies as well. And will it help SMEs to grow and thereby create jobs, improve standards of living, reduce social injustice, generally promote economic growth, and do all the wonderful things that can be accomplished by secure transactions reform? But I also try to determine whether the proposed law will work as a matter of corporate finance, encouraging banks and other lenders to extend credit in the larger credit facilities as they seek to accommodate the globalized financing needs of their customers. And here we're not speaking so much about financing freestanding domestic SMEs as we are about financing large multinational companies with borrowers and guarantors in multiple jurisdictions. And I think it's absolutely clear that the proposed draft law satisfies both of these tests really, really well. It's concise, it's easy to understand, it balances the interests of the transferor, the transferee, and the debtors on the receivables. It promotes transparency through the registry, which is at the heart of any modern secured transactions regime. It applies to outright transfers and as well as security interests. It applies to both international and domestic financing arrangements. It accommodates securing future as well as existing obligations. It covers existing and future receivables. It contains a very powerful overrides on bans on assignment, which I'll talk about in a moment. It provides clear priority rules. It's flexible enough to accommodate the many forms of receivables finance that we see in the market today. And it provides simple and balanced non-judicial enforcement mechanisms and recognition of transfers in insolvency. In short, it provides everything I look for in law when I'm evaluating receivables laws of another country for a client and for members of the SFNet. A couple of additional points before I close. As you know, the concern has been expressed by some that the model law on factoring only deals with receivables and will divert attention from the UNCITRAL model law on secured transactions, which covers a broad array of personal property collateral. But I absolutely do not share that concern. As has already been noted, not all countries are ready to adopt a comprehensive secured transactions regime, but they may be willing to stick their toe in the water by promoting receivables financing, which after all comprises a rather large segment of secured finance. Moreover, secured transactions reform, as we know, is a high stakes game. And anything that moves the STR ball forward is extremely valuable. And I feel that the model law on factoring will do so in a very, very significant way. But on this point, Peter and I were chatting before today's session that one project for the future might be a sort of a kit or a blueprint to make it easy for countries that adopt the model law on factoring first to move to the more comprehensive model on secure transactions. And just an easy way of accomplishing that result, should they realize that the success that they have with the model on factoring inspires them to move to a more comprehensive law. I want to make a brief and special note of the model law's treatment on restrictions on the assignability of receivables. It's stronger than the UNCITRAL model law provision, and as Marek noted, it renders bans on assignment of receivables unenforceable for all purposes, while the UNCITRAL model law preserves the right of the debtor on the receivables to sue for damages for breach of the restriction. I can just tell you as a matter of practice that eliminating the right of the debtor to sue for breach is a significant improvement in my view, because prospective financiers will not have to worry that they may be inducing a breach of an anti-assignment clause, or that their borrowers will become embroiled in litigation from their debtors for breach of the ban on assignment. So this provision alone should go a long way as well in reducing the diligence costs in receivables transactions. And finally, I think that and this has already been noted, I think the model law adapts well to the increasingly wide range of receivables financing products that we see on the market, not only factoring and asset-based lending products, but also receivables purchase agreements, supply chain financing, and receivables platforms. These products, which increasingly rely on technology, nevertheless need to satisfy basic principles of secure transactions law, and having greater uniformity and clarity in the law as a result of this draft law will make it easier for prospective lenders and investors to structure and to evaluate these products and make prudent financing decisions. So thanks for your time. I think it's a great product, and I urge you to consider it for your respective countries.
Richard, thank you very much for those comments. And again, I think your comments indicate that the industry's been very involved, and the concerns that one would have from an industry point of view has been addressed as best as we can.
Yes.
So again, thank you. At this point, I'd like to open up the floor to questions and comments from folks. As Will pointed out, the draft is out for about another week or so for public commentary. We're going to have one more meeting in December to finalize the draft. And so we're very, very interested in comments and concerns or questions that people might have. Again, you can use the raise your hand function, or you can put your comments in the chat box, but I open up the floor. Is that Felix? Please.
Yes, it is Feliz. Thank you. Thank you. Can you hear me? Okay. I am Filiz Ünal, and I'm working in the Association of Financial Institutions in Turkey. And first of all, I would like to thank Peter, because I received this model law from Peter FCI. And in Turkey, we have a law which was enacted at the end of 2012. And also with this law, according to the relevant article, we were assigned to establish a registry system under our association. And it is really very beneficial. Since its inception, 1.4 million double assignment already were prevented, and also 40 million documents recorded to the system, and 95% of documents are e-invoices. We have also integration with the e-invoice system of the Ministry of Treasury and Finance, so we can verify actually the e-invoices are arising from a real trade transaction and valid. I believe such law and also registry systems are very important, especially for developing countries. We are working on the model law, and we will give our comments also in written to Peter. But really, it is a great job. Thank you for this great job. It's all what I would like to give as supportive information. And also sometimes I'm invited by FCI or some emerging markets regulatory bodies to introduce our law and registry system. Thank you.
Thank you very much for those comments, and please, as you've worked through the model law, please filter your comments through Peter, who will obviously get them to the working group immediately. And thank you for just the background information on what's going on in Turkey. It's very interesting. And any other, David? You're on mute.
Thank you. This is David Tadji in Washington, D.C. I would just want to say what a great job your group has done on presenting this model law. I've worked on some model laws myself, and this is a fantastic job you've done. One thing I wanted to talk about, it was something that was touched on in some of the comments today, is whether or not we should be talking about this as a model law of secure receivables finance as opposed to a model law of factoring, because as was noted, this covers both outright transfers and transfers to security. And when people think of factoring, a lot of people think of old line factoring, and of course it has invoice discounting and this and that. But it seems to me that just on the title, I think where this has evolved to, it should be broader than what it is.
Thank you very much for your comment, and you might have seen me chuckling, as was Will and a few other people. That very point was one that we had an extended discussion among the experts group, because you're quite right. The model law does go beyond traditional factoring. At this point, I think the consensus was that as a means of promoting the instrument, we wanted to emphasize its sort of core factoring function, even though, as you very correctly pointed out, the model law goes beyond that. And there were some strong opinions on the title of the act for that very reason. So thank you. And I'm not sure that the end of that discussion has been had. We'll see. Again, thank you. Any other comments, questions? Diego.
Hello, this is Diego Tavecchia from the Italian Factoring Association. Thank you very much for the presentation and also for the good job you have done with this very interesting model law. Italy, as also some other countries, I think, have its own law on receivables transfer, and we are fully aware of the fact that this kind of model law will, whether you want it or not, become a benchmark also for any future development in the space of receivable transactions, so receivable-based transactions. So thank you very much for the job, but I would like to underline that we need some clarifications on some of the points of the model law, in particular with regard to the scope. We have seen that there is a broad definition of what is a receivable, but you explicitly exclude receivables from immovable properties, both leasing or selling of immovable properties, and we don't understand why, because these are very legitimate transactions that may be part of a factoring agreement, at least in Italy. Also, we have seen that the registry seems to be at the core of this model law, with so many of the provisions included in the model law being intended to improve the effectiveness of the registration of a notice. But we are not convinced about how this would fit with transactions without notification to the debtor, how to assure confidentiality of the agreement in the case of without notification transaction. And also we didn't find clear indications of the effectiveness of the registration in the case of insolvency of the client or of the debtor. In some countries, such as in Italy, for example, you may have the possibility to face avoidable action on the transfer of receivables from the insolvency trustee that could make the assignment ineffective. And we would like to understand if this has been taken into account during the model law, because we didn't find much reference to this kind of issue. Finally, but maybe this is something that could be included in the guide of enactment that I think Marek was prospecting earlier. I would like to underline that the industry has been involved, and maybe it is still involved, in a process of deep innovation and digitalization to speed up the time to finance of factoring. So any requirement to register the assignment, I think it should be considered, it should be implemented in a way that doesn't hamper the need for a very quick reaction from the factoring company to the assignment of receivables, which means the use of a very responsive technology. I think this should be taken into account. And for the time being, that's all from my side. I'm sorry for this long list of items, but I would like to take this occasion to tell you that we have read the model law with a lot of interest and also admiration of your job.
Thank you very much. And those are wonderful observations. I'm wondering if, Will, did you have any initial responses? You may not have. I know you're taking notes.
Thanks, Henry, and thank you so much for those questions, Diego. We're so pleased to get them, and this is exactly the kind of feedback we want now, so that the working group can go away and consider these kinds of issues before we finalize the draft and submit it for adoption. As my first point, given these are highly technical questions, I strongly urge you to submit them as written feedback on the model law, so we can provide them. Not all of our working group experts are online right now, so apologies for the ambulance in the background if you can hear it. So please submit them in writing as with all comments and questions received today. I don't think I'll go into detail on as to why we excluded a movable property from the definition of receivables and the notification factoring issues in relation to registrations at this point. Perhaps if we have time at the end, I could bring it back to perhaps Marek and Richard as to why they were excluded and why initially industry actually asked them to be excluded from the draft model law and factoring. But at this point, Henry, it might be better to sort of get some other general comments if they're out there, and then if we have time at the end, refer back to these more technical questions. Thank you.
Thank you, Will. And if we have time, we can come back to them. In the guide to enactment, there will be a long section in the beginning that will explain these scope issues and why certain things were excluded. Mark, did you want to respond?
Yeah, I can respond very briefly in a non-technical way. Thank you, Diego. Those are excellent suggestions and questions. And as you yourself suggested, some of these will be covered in the guide to enactment, as the factoring model does cover some aspects of insolvency, preserving the effectiveness of a transfer in insolvency, but however contemplates that insolvency law would have its own rules on preferences and fraudulent transfers that would be applicable regardless of what the factoring model law states. So this is already implied that the law applies. With respect to registration, I don't think that the notice registration interferes with the non-notification financing, as the debtor would not be identified in the registration. It would be a very general notice covering receivables existing and future. And then finally, as to immovable property, that's similar aspect to insolvency. As in many regimes, receivables arising from immovable property are sort of at the intersection of immovable and movable property law, as an interest in movable in the land could also extend to the resulting receivable. So this would be sort of going beyond our mandate and interfering potentially with any applicable immovable property law. But this is, again, a very useful aspect to mention in the guide to enactment as to how states may wish to go about resolving those conflicts, but not a matter of the text of the model. Thank you.
Thank you, Mark, for those comments. Any other questions or comments? I don't see anything in the chat. I don't see any hands up. And again, David.
I wanted to make another observation then. One of the things that we've struggled with here in the US, as Jonathan and Richard and Peter and Bob and some other people know, is problems created by merchant cash advance financing, where in the go-go years, and probably even now, people had effective interest rates of, I've seen deals of as much as 200 to 300%, which is really abusive, and it actually ends up putting someone out of business. So New York and California and some other states have now, as a draconian response to that, have come up and said, okay, now the factors and the asset-based financiers have to do, comprehensive upfront disclosures of what the effective APR is going to be. And I don't know that that belongs in the law. Perhaps this would be in the guide for enactment, but I just wanted to put that on the table, is that what we want to make sure we do is have a product that gives good financing for people, not financing that's going to end up, for most people, putting them under the table.
Thank you for that comment, and I think certainly it's been in the mind of the working group all along that we wanted something that worked for all parties, so that it didn't create disadvantages. Maggie?
Yes, hello, thank you. It's Maggie Wessel here from the German Factoring Association, but also Vice President of the EU Federation for Factoring and Commercial Finance. Thank you for hosting this, for giving the floor to us to make some comments, and thank you also for your good work on this model law. My question was more about something which comes in the future, but was mentioned today, the guide to enactment. And you said that the guide to enactment will also most likely cover issues like regulatory, prudential, and also accounting aspects. Do you already have more a possibility to elaborate a bit more on that, or to give more insight into what you intend to cover more exactly? That would be helpful. Thank you.
I leave it to some other members of the experts group if they want to add to this. Right now, the guide to enactment has a laundry list that goes on very long, because there are all sorts of potential topics in there. And after we complete the draft, we will go back through this long laundry list and see if it's comprehensive. And also we probably will start cutting some stuff out, because it's a fairly, if we put everything in the guide to enactment that we suggested might go there, it'd be about 600 pages. And so I think we'll compress it. At this point, I don't know that we can give any definite guidance or suggestions of exactly what will be in the guide to enactment. But as we move to that stage of the process, which is after the draft has been approved and we're working on the guide to enactment, we will again seek comments from folks on what would be useful in that guide to enactment. Will, did you want to add anything here?
Thanks, Henry. Just very quickly, Maggie, that's an excellent question. And the reason that Henry and his colleagues in the Governing Council have already pre-approved a guide to enactment, even though we haven't finished the underlying instrument, is because there is broad consensus of how important it is to give implementing states additional guidance on these essential issues essentially, as Henry said, the exact content is yet to be considered, but there are two big baskets of issues, which is additional guidance to states for them to better understand the rules in the model law and factoring itself, because of course it's a highly technical instrument, and also as noted, these sort of associated issues such as regulation and regulatory prudential matters that states must take into account when they're implementing these laws, because they're interrelated and cannot be disconnected. This also covers those sort of treatment of digital assets and other such matters. As Henry said, we have a large basket of issues to discuss in that regard, and we won't start going through them until the model law and factoring itself is finalised. But the good news is that we strongly encourage you to participate in that process as we engage on it in the second half of next year. We have time to deal with those broader issues and how the model law and factoring will interact with these other areas of law. And we think that the guide to enactment will prove essential to states to make sure that when they implement the model law, it fits well within their broader legal regulatory framework. Sorry, I can't be more precise, but I hope that helps. Thank you.
Thank you, Will. And I noticed that Mark very helpfully put in the chat that in some of our earlier working documents, we've begun to sort of outline some of the regulatory issues that might be in that guide. Any other questions, comments, complaints? Again, I want to encourage you to, if something doesn't come up this morning or this afternoon, to submit your comments. Diego, please.
It's me again. Sorry about that. I didn't want to monopolize the floor, but since there are no other questions, I would like to have a very short reaction to Marek's comment about the confidentiality of the agreement, which would be consistent with the fact that the debtor would not be identified into the registry. But in this case, I see this working in the case of the assignment of the whole turnover of a client. But if the assignment is about only a debtor or some debtors, which is the practice actually in Italy, maybe also in other countries, then I'm not sure how the registry would diversify between possible multiple assignment by the same client on different debtors. And that's why we see an issue for not notification factoring, because we didn't see any other way to specify what we are transferring with the notice, then including the debtor's identification. That's food for thought. Not that we need to reply today, but that's something that we will probably include into our reply to the consultation. Perfect.
Thank you very much for those comments. Any other observations? We've got a few more minutes. If people have any final comments. I don't.
Henry,
yes.
if
Yeah,
I may,
please. Well,
again,
go ahead.
Thanks, Henry. In the absence of any other comments, I'll again take the ability to take the floor myself. I would be interested, given that we have 40 stakeholders working in different factoring jurisdictions, it would be interesting to know, and also people like Marek and Murat, and I think Elaine's gone now, but people who are actually engaged in the reform of secure transactions frameworks around the world. Obviously, one of the issues we'll be facing once we have the model law and factoring adopted next year is how we go about assisting states who are already in the process of reforming their secure transactions laws and their factoring laws, and trying to, I guess, ensure that they use the model law and factoring as soon as it's ready, as the basis for their undergoing reform. So I wonder if I could be so bold as to sort of ask those stakeholders engaged in secure transactions reform and ongoing factoring reforms, whether they could identify sort of any countries or jurisdictions which they're working where they think that the timing might be quite good next year to use the model law and factoring as a basis of undergoing reforms or contemplated reforms in the near future. It would be useful for the Secretary to have that information as we go about finalising the document and future planning. Thank you.
Thank you, Will. And any takers?
Yeah, I can respond briefly to this so that the group understands how this has been already used. Even though it's still a draft, we have seen countries, and Murat just mentioned a project in Georgia, but there are many actually other jurisdictions that are in the process of reforming their factoring or secure transactions laws, and they are trying to figure out how to put the two instruments together so that they work in a cohesive fashion. So for instance, with Murat, we helped UAE draft the secure transactions law, which was enacted 2020, and then a factoring law, which was enacted 2021. So that the process was slightly different from the one, Will, that you explained, that a country first might take a small step and enact a model on factoring and then use that as a springboard to a broader secure transactions reform. Actually, we have seen the reverse process where countries have already enacted some type of a secure transactions law, which may be bare bones or not quite consistent with international standards, and realize that this doesn't really work well for the factoring industry. So we have other projects with the EBRD in Jordan, for instance, which has a similar situation as the UAE. So countries are not waiting for the model law to be adopted. Countries are using already the draft that we have made available to them and adopted. But perhaps Murat will be better positioned to speak to some other ongoing projects that he's familiar with.
In the interest of time, I'm just going to give one illustration, a very recent one in Ukraine, where also we've just recently launched the asset-based finance program there, but we've been engaged with stakeholders for a number of months. In fact, Feliz kindly organized a knowledge exchange session for us to share the Turkish experience on setting up the supply chain finance platform. But on the legal and regulatory track, we're working with the National Bank of Ukraine and the Ministry of Economy. Just a couple of weeks ago, we had a working group in the task force, and the National Bank confirmed that they have reviewed the UNIDROIT model on factoring. They're very happy with the text, and that they want to incorporate as much as possible in their own text that they're currently preparing, also with assistance from EBRD and IFC. And the situation there will be exactly reversed to what we've seen with Mark in UAE, where we started with the secure transactions law, and then the government realized that we may actually start to kind of narrow down some of the fields within the secure transactions spectrum. In Ukraine, if the factoring law says the light of the day and the registry is operationalized, we think that this can actually help, set the government authorities on the path of reforming the existing pledge law, which is outdated, and secure transactions law that's been passed in 2004 needs significant improvements. So here we expect that with introduction of the factoring law and creation of the registry, when lenders and financial institutions will get a sense of how easy it is to file a notice, simple notice on electronic platform, rather than going through the hassle of registering documents and paying significant fees and so forth, then it will inform other policymakers about the need for and importance of reforming secure transactions law, and perhaps expanding the factoring registry to kind of all kinds of security rights under the modern secure transactions law. But the UNIDROIT model on factoring, we expect will be that first step that will help set the country on the right path of reform. Thank you.
Thank you, Murat. Very, very helpful. Any other comments? observations? Again, I want to emphasize that we welcome any thoughts you have after this session that you want to send to us. And there doesn't seem to be any other comments. We intend, subject to obviously any objections by participants today, to take our session today and post it on the UNIDROIT website for future reference for folks. But if anyone wants to have their contributions excluded, please let the Secretariat know, and we'll do that. And if there are no other comments, I want to thank all the participants, everyone who spoke. I want to particularly thank people who've raised questions and made comments, and I look forward to any additional input that folks have. And I hope this has been useful to folks today, wherever you are. And thank you very much for participating.